Hello friends, Namaskaram, how are you? Har Har Mahadev, Jai Shiv Shambhu. In today's class, I will discuss one of the most important judgment of Odisha High Court, which is quite recent. The judgment is in favor of the concerned accused. In that case, the concerned case filed for check bounce had been quashed by Honorable High Court on ground that the debt is not legally enforceable. So basically, I will discuss the strategy of the accused, and in case we are fighting a check bounce case, what could be our strategy so that we could put up a strong defense and could be succeeded accordingly. So I request to all of you to maintain a proper notebook with pen or pencil, and directly we are going on the screen. Please note down the point, maintain your information, and in case you are having the resembling problem, the present content could be quite useful for you. So directly we are moving. Basically, in a check bounce case, the accused is having certain fundamental questions. How I can win, what will be my strategy, and how to proceed. In absence of knowledge, he consulted with those persons who are unexperienced, and in absence of specific defense, the accused inter alia defeated even in a strong case. So basically, we have to understand the golden rules, the golden principles, so that we could be conceptually clear, and whenever we are going to reply or whenever we are going to contest the case, we could be succeeded accordingly. The burden in a check case is on the prosecution, means on the complainant. The prosecution has to prove the case beyond reasonable doubt. The accused is not supposed to prove the case beyond reasonable doubt. He is supposed to put up a probable defense, in consequence of which he could create a suspect in the case of prosecution. And apart from that, there is presumption of section 118 and 139 of NI Act, even though it could not be presumed that accused is guilt. Still, the prosecution is required to prove the prime element. If prime elements are on record, there might be a presumption, but presumption could be rebutted by the accused by submitting a probabilizing defense. There are multiple ways by which we could submit a probabilizing defense on record, and I have discussed the same in multiple videos. Today, I will discuss one of the most important variant. That is, if a check is not towards legal enforceable debt, in that scenario, check bounce case will fail 100%. So basically, we could say that legal enforceable debt is key performance indicator in a check bounce case. Please be noted. Now we will take an example. Mr. A wants that his son, Master B, is to be admitted in a medical college. But someone advised him that he must take admission in the government college. But we know that it is not easier to take admission in government college. So Mr. A inter alia consulted with Mr. C. Mr. C inter alia took 100% guarantee regarding the admission. Finally, Mr. A gave rupees to Mr. C. It is allegation of Mr. A that the money has been misappropriated and he has been cheated. Finally, Mr. A has lodged the FIR against Mr. C. In the meanwhile, Mr. A has filed a check bounce case. The case had been challenged by Mr. C before Honorable High Court on ground that there is no legal enforceable debt which is must to bring the prosecution as per section 138 of NI Act. And apart from that, it is a condition of Mr. C. Already he is having a case against him under section 420 of IPC along with 420 IPC, Section 138 of NI Act cannot go together. But contention number 2 had been rejected by the Honorable High Court. But as far as contention number 1 is concerned, the court observed that if there is any bribe or undue money which is given towards the admission in government college, in that scenario, there is no legal enforceable debt and same could not be recovered. So basically, it is one of the most important instance which is observed by Honorable Odisha High Court. Judgment date is 4th of March 2025. So in that case, the proceeding had been quashed by Honorable High Court. So the present judgment is going to set up the three important fundamentals. Whenever we receive a notice for a check bounce case, please give reply. And apart from that, we are not supposed to prove our defense beyond reasonable doubt. We are supposed to prove our defense by theory of probabilizing defense. The prosecution has to prove the prime element. If prime elements are on record, the court may draw the presumption. And to rebut the presumption, the accused is required to sustain the defense that come with the preview of probabilizing effect. We may take another example also. Mr. A says that I have given rupees 2 lakh to Mr. B. To pay the same, Mr. B has issued a check. It is bounced and finally case is instituted. Mr. B says that out of 2 lakh, 1 lakh has been paid and there is a proof regarding the same. But this fact has been concealed by Mr. A and there is no endorsement by Mr. A intentionally. So in that scenario, Mr. B is going to put a clock on the legal enforceable debt. The defense is valid. It is going to create a probabilizing effect. In that scenario, Mr. B will be succeeded. So in that way, we have to contest and have to put up our strong stand on the record. So everything is easier. It depends upon us in which manner we are going to neutralize the issue. So I think that I have specified you the vindication to the grievances in the easier way. See you in the next lecture.